Hello, everyone. I'm Alonzo Martinez, Associate General Counsel at HireRight, and this is On the Horizon, our first compliance update of 2022. While I'm a lawyer, today's webinar is not intended as legal or compliance advice. My intentions are to give you information that you'll take as talking points to raise with your teams and your legal counsel. Before we begin, as always, I want to cover a few housekeeping items. During this webinar, please take the conversation to Twitter using the hashtag HireRightWebinar. In order to receive HRCI or SHRM credit, you must attend the full live session of this webinar. Credit information is going to be emailed a few days after the webinar. We're not providing copies of today's slides. However, we will send you an email with a link to a recording of this webinar session. If you experience any audio or video issues, please refresh the browser window by clicking F5 on your keyboard or send us a message using the Q&A icon at the bottom of your screen. Anne is producing today's webinar and will be monitoring the feed for any technical issues. After the presentation, we'd appreciate getting your feedback. Please take our brief survey and let us know if this session was helpful. My focus is to create sessions that are meaningful, so we welcome ideas for future topics. So please take 60 seconds out of your day and let us know what you think. And again, press F5 on your keyboard to refresh this presentation anytime you experience any audio or video problems. As we head into spring with warmer and longer days, we see legislators putting in longer hours as well. In fact, we're just past the peak of the legislative calendar with around 30 state houses still in session and a little more than 15 having adjourned for the year. And 2022 is shaping up to be pretty different from 2021. There's been a noticeable decline in the number of bills introduced that directly affect things like criminal screening, but we've seen an uptick in bills concerning pay equity, cannabis legislation, and privacy legislation. So let's talk about what's on the horizon for 2022 and beyond. And you can see today's rundown on the screen. I'm going to provide an overview of the current state of the law, talk about newly passed or enforced measures in the first quarter of 2022, and then we're going to talk about what's on the horizon or legislation that I'll be keeping a tab on, as well as some compliance considerations for you so you can start having these compliance-related discussions amongst your teams and your legal counsel so that you can prepare for these changes to your screening programs in the event that any legislation makes it across the finish line. So as always, we have a lot of ground to cover today, and I'm going to try and keep a quick pace through these topics. So please don't consider this to be a comprehensive discussion, but it should provide you with a good overview of things that are going on in the first quarter, along with things that are going to happen on the horizon. And as always, when you fill out the survey, let me know if you'd like me to focus on a particular topic. I'm happy to build out a more thorough webinar for you or even speak with you individually. So settle in for the next hour. And remember, if you have any questions during this webinar, use the Q&A icon at the bottom of the screen, and I'll try and cover those at the end. We're going to kick things off today with a discussion concerning criminal history reform, starting with a review of ban-the-box laws. As a reminder, ban-the-box laws delay when an employer can inquire into a prospective worker's criminal history. And here's a look at the landscape of ban-the-box jurisdictions impacting private employers at the state and local levels. Again, this is private employers and not public employers. So in all 39 of the jurisdictions that you see on the screen, you can't ask the "have you ever been convicted of a crime" question until some later time in the hiring process. In the 18 jurisdictions you see on the screen on red text, the ban-the-box measure applies to any form of work for monetary gain. So that means if you pay somebody to do a job, then they're subject to the ban-the-box measure. So this includes not only your traditional employees, but also contractors. That's a frequent misstep in screening programs. Again, anything in red applies to contractors as well. If you've attended my previous webinars, you know that I love to say that not all ban-the-box laws are created equal. In all ban-the-box jurisdictions, you generally can't ask the candidate if they've ever been convicted of a crime during the initial application or request a criminal background check as part of that initial process. Those are the jurisdictions in the gray standard box. But then there are some jurisdictions that require special handling, and you're going to see those on the screen in the gold column that require that you identify the criminal conduct that might disqualify a candidate from hire, and you need to provide them with that notice as part of the pre-adverse action process. Then there are those in the aqua column that require that you conduct and provide an individualized assessment that relates to the candidate's criminal conduct as it relates to their job as part of the pre-adverse process. And then you have Los Angeles and New York City shown in blue on your screen. You also need to provide additional city-provided notices. The city tells that you can also provide substantially similar forms as part of the pre-adverse action process. So the bottom line here is, as you can see, you can't adopt a one-size-fits-all model for compliance. You're going to have to modify your adjudication, your pre-adverse and adverse action processes to align with a particular jurisdiction's law. So with that said, just a quick reminder, if you are a HireRight client, you can use HireRight's compliance workbench solution to manage your ban-the-box obligations. The solution is made available to you for free, so let us know if you want more information about Compliance Workbench and its use for ban-the-box jurisdictions when you fill out today's survey. So let's jump in and look at the only jurisdiction to enact a new ban-the-box law so far in 2022. And that's actually a city, the city of DeSoto, Texas. So employers in DeSoto, Texas, that's with 15 or more employees within the city, now need to conduct an individualized assessment that identifies the rational relationship between the candidate's criminal history and the job to which they've applied. Employers don't have to provide a copy of that individualized assessment to the candidate, but you're going to want to retain that individualized assessment as part of the candidate's talent file. So again, that's applicable to DeSoto, Texas, which is outside of Dallas, Texas, and you'll need to conduct an individualized assessment, but you need not provide it to the candidate. So let's move on and talk about ban-the-box laws that are on the horizon. You can see on the screen that there are several ban-the-box bills that have been considered in the first quarter, and I've summarized them for you in the chart. On the left side of the screen, you're going to see the jurisdictions listed, whether that be a city or a state, followed by the scope, meaning the types of employers to which the laws apply. Then when you can inquire into the candidate's criminal history, then if you have to provide a specific notice before requesting a criminal check, then if you have to conduct an individualized assessment of the individual's criminal history against the responsibilities of the position to which they've applied, then whether you need to provide the candidate with a copy of that individualized assessment, and then if you have to identify the criminal history that's specific to the individual that may disqualify them from hire, and finally, whether or not you need to modify any of your standard pre-adverse or adverse action letters. So that's the breakout at the top. For what it's worth, this is the same matrix that we use in our ban-the-box white paper, which is available in the HireRight resource library. If you have any questions about our ban-the-box resources, let us know if you need any help finding those resources when you complete today's survey. So what I'm going to do is walk through a few of the more salient points that aren't necessarily covered on the screen. Couldn't include everything in the chart. So starting with Arizona, the bill as drafted would limit criminal history inquiries to the previous 7 years. And the Arizona bill also defines, interestingly enough, an interview as any verbal interaction between the employer or representative relating to the duties of the position. So that's a relatively loose description, but that relates to the timing of your ban-the-box inquiries. In Iowa, the state's proposed ban-the-box bill will require that employers modify their job posts or descriptions to identify the specific law or regulation that applies to the position and the types of criminal offenses that would prevent a candidate from being hired for the position if an employer believes an exception to the state's ban-the-box law applies. So again, in Iowa, you can clearly state your exception as part of the job posting or as part of the job advertisement, and you have to make that known to the candidate initially. That's the same thing in Kentucky, very similar at least in Kentucky. In Kentucky, their proposed bill permits employers to notify applicants that a law or policy will disqualify an individual with a particular criminal history from employment in specific positions. So essentially, the goal of this disclosure is to permit candidates to opt out of pursuing a job that doesn't align with their criminal past. So you put that information out in front of them, they opt out, they're not part of your candidate pool. And then there is Michigan's proposed ban-the-box law. As you can see on the chart, Michigan's law, if passed, will require that you conduct an individualized assessment of the candidate's criminal history. As part of that individualized assessment, you're going to have to document the duties and responsibilities related to employment that's sought by the candidate, the effect that that criminal offense will have on the ability of the candidate to complete the job. So that is the rational relationship between the criminal history and the job to which they've applied, the amount of time that has elapsed since the criminal offense, the age of the candidate at the time of the criminal offense, and the frequency and seriousness of the criminal offense. And then finally, any information produced by the candidate or produced on the candidate's behalf regarding their rehabilitation or good conduct since the occurrence of the criminal offense. So that is your basic green factors, essentially, the EEOC's green factors as it relates to criminal history and the job that the individual will perform. So those are the steps that you'll have to run through as part of the individualized assessment. You're going to also need to modify your adverse action process. As part of the adverse action process, within 15 days of revoking a conditional offer, you're going to have to provide the candidate with a copy of any records that you obtained in consideration of the candidate's employment, including but not limited to their criminal records. So to the extent that you conduct research outside of your standard background check process, as part of the candidate's report disclosure, you would then need to include these additional records as part of the adverse action process. Again, that is Michigan's proposed ban-the-box law. Let's take a look at competing bills that have been introduced in New York, Pennsylvania, and South Carolina, starting with New York. Now, you might remember that New York already has a law in place that relates to an employer's consideration of a candidate's criminal history. And that is Article 23A of the New York State Corrections Law. And what Article 23A tells us is that we have to conduct an individualized assessment of that candidate's criminal history against the specific factors outlined in Article 23A. But the state of New York doesn't currently ban the box. So what is ban the box again? It doesn't prevent an employer from inquiring about a candidate's criminal history prior to a conditional offer. So that is where this first measure comes into place. You can see that S 4701 maintains the individualized assessment requirement, and it also bans the box in the state. There is also a competing measure, that's S 8621, which is the second row on the screen. That measure not only requires that you complete an individualized assessment, but as drafted, it would also require that you provide that individualized assessment as part of the adverse action process. So if you hire in New York City, you might want to think about the changes you'd need to make to comply with either measure. And if you hire in the state in general, again, you need to think about these changes. At minimum, though, you need to ban the box from your initial employment application for any workers in New York if either of these measures pass. Let's look at Pennsylvania's measures. The first bill, that's House Bill 378. It's what I'd consider a no-frills ban-the-box law that prohibits employers from inquiring into a candidate's criminal history until after a conditional offer of employment has been extended. The second measure, that's HB 2452, interestingly enough, it doesn't ban the box, but it does impose individualized assessment obligations on the employer. So if passed, for HB 2452, again, you wouldn't have to ban the box, but you would need to conduct an individualized assessment and provide that assessment to the candidate as part of the pre-adverse action process. You would also need to wait at least 7 days from providing the candidate with the pre-adverse action notice before you could send out the adverse action notice and withdraw the candidate's offer. So that, again, is a big difference between the standard 5-day notification period or waiting period between pre-adverse and adverse action notices that the FCRA generally requires. In Pennsylvania, you need to allow for at least 7 days of this measure passes. And just as a reminder, in Philadelphia currently has a 10-day waiting period. So be aware of those nuances of ban-the-box laws. Again, Compliant Workbench is a good solution if you're a HireRight candidate that can help you manage these timing and differences between various ban-the-box jurisdictions. Let's wrap our discussion of ban-the-box laws that are on the horizon by looking at 2 measures out of South Carolina. The first proposed measure is a basic ban-the-box law that prevents employers from inquiring into criminal history until after a conditional offer of employment has been extended or after an interview has been conducted. And then there's the second measure that would do the same, but it would also impose a requirement that employers conduct an individualized assessment of the candidate's criminal history. As you can see on the screen, while you need to conduct the individualized assessment, you wouldn't need to provide that to the candidate. That is a very popular thing, conducting individualized assessments. Again, that aligns with the EEOC's guidance to employers on the use of arrest and conviction records, but not necessarily providing that individualized assessment to candidates. So that is our look at ban-the-box laws that are on the horizon. If you've attended my previous webinars, you know that I love audience engagement. So what I'm going to do today is pretend that we're in law school, and I'm going to walk you through a fact pattern, and then I'm going to ask you to decide the case with our first poll question. So listen up as I go through this fact pattern, and again, I'll ask you to decide the case at the end. So this will be a test of our criminal history reform knowledge. Today's case comes to us from the Wisconsin Supreme Court. So here are the facts. Our plaintiff applied for an application specialist position with a lighting manufacturer. And this lighting manufacturer is also a retailer of commercial lighting applications. So let's talk about the job. The application specialist position was located within a large mixed-use facility. It's a corporate campus that houses around 1,000 employees and a little over 600,000 square feet. So what does the job entail? Well, an application specialist designs lighting systems for commercial customers, and it's what would be characterized as a somewhat stressful job. You have to meet customers' demands against production schedules, you have to understand their needs, and you have to deal with budget constraints. People who work as application specialists are generally unsupervised and they work independently. They're also required to visit customers and travel to trade shows on occasion independently with no one else. So the lighting manufacturer, that's our defendant or the employer in this case, gave the plaintiff a job offer conditioned on the successful completion of a background check. And what does the plaintiff's background check turn up? Well, it reports that 2 years prior to his application for employment, the plaintiff was convicted of 8 counts of domestic violence against the plaintiff's girlfriend who lived with him. Specifically, the plaintiff pled no contest to 2 counts of felony strangulation and suffocation, 4 counts of misdemeanor battery, 1 count of 4th-degree sexual assault, and 1 count of criminal damage to property. So what does the defendant, our lighting manufacturer, do? Well, they rescind the plaintiff's job offer based on the results of his background check. And then what does our plaintiff do? He files a complaint with the Wisconsin Equal Rights Division, claiming that the defendant discriminated against him based on his criminal history. One other data point for your consideration as you decide this case, as part of the discovery process, the process about learning more about the defendant and learning more about the alleged discrimination, the defendant, the employer, also learned that the plaintiff had been convicted of battering a different girlfriend around 14 years earlier. So those are the facts. We have a plaintiff that has a criminal history for domestic violence, at least recently within the last 2 years, and then further out within the last 14 years, and an employer who disqualified the plaintiff from hire based on his criminal history for that application specialist position. So here we go. Did the employer discriminate against the defendant, against the plaintiff applicant? You have a 50-50 chance of getting this right. Let's have you decide the case. Who wins here? Is it a verdict for the plaintiff who alleges discrimination, or was the defendant justified in rescinding the job offer based on the candidate's criminal history? I'll give you a few seconds to get your answer in. All right, so here are our poll results. The majority of you say verdict for the defendant employer. And you're correct. It is a verdict for the defendant. So let's talk about the reasoning behind the decision. And then I'm going to give you some practical takeaways for your consideration. So the court focused on the concept of substantially related in its analysis, and I parsed that out for you on the screen. In the opinion for this case, the court described a 2-part analysis used to assess if a conviction is substantially related to the job. The first part of the test is to assess if there are opportunities in the workplace that would allow someone with a history of domestic violence to recidivate or to commit those acts again. And the second part of the test is to evaluate the character traits of the individual who commits a crime of domestic violence. Again, looking at the screen, it's the material circumstances fostering criminal activity that need to be considered. That means the circumstances in the workplace that present opportunities to reoffend, considering the character traits revealed by the circumstances of the domestic violence convictions. So the court found that the circumstances concerning the plaintiff's previous domestic violence convictions revealed his willingness to use violence to achieve power and to control another person, his disregard for the health and safety of others, and his inability to control his anger and his other emotions that could affect his workers. The court viewed the plaintiff's convictions for strangulation and suffocation as particularly troubling, given their proximity to homicide. It also noted the seriousness and recency of the plaintiff's offenses and the pattern of violence emerging from that criminal history. Again, the most recent convictions were only 2 years prior to his application. So when the court looked at the application specialist position and the opportunities for the plaintiff to potentially reoffend in that role, the court found that it involved a largely independent work without close supervision, including visits to customers' facilities and traveling to trade shows, which involved unsupervised use of rental cars and, of course, staying in hotel rooms outside of the purview or the guise or the view of the employer. The court also found that the job involved regular interaction with coworkers and customers and responsibility for satisfying the customer's demands. So the court found that the plaintiff's criminal history was substantially related to the job and that the employer was justified in disqualifying the plaintiff from hire. Now, if you review the opinion in this case, what you're going to see is that the court relied heavily on the testimony of an expert witness who spoke to the nature of domestic violence perpetrators, and in particular, those who have engaged in strangulation. And it's that testimony that really helped to derive the decision in this case. So this decision could place into question an employer's ability to demonstrate a substantial relationship between past criminal conduct and its potential to impact the workforce for what we would consider borderline cases, such as domestic violence, simple assault, DUIs, other traffic offenses, and any kind of disorderly conduct. So I think the practical implication for those of you, especially those of you who hire in Wisconsin, is that you may want to review this case with your legal counsel, and you may choose to engage in an expert opinion when conducting individualized assessments of criminal history that lie on the fringe of being job-related. And that is our criminal history reform discussion. Let's shift gears and talk about pay equity measures. Remember that pay equity measures look to promote equal pay for equal work, and will often include a ban on asking candidates about their former compensation until some later point in the hiring process. And here is a look at jurisdictions with effective salary history bans broken out by state on the left-hand side of the screen, or county or city on the right side of the screen. While HireRight does not verify salary history, there are other aspects of pay equity laws, and in particular wage transparency laws, that I want you to be aware of. So again, what you're seeing on the screen are states and counties and cities that prevent employers from asking about a candidate's former compensation. This is the only salary history ban that was recently passed with an upcoming effective date, and that is Rhode Island. In brief, Rhode Island has implemented a salary history ban and now requires pay scale disclosures. If a candidate volunteers their salary history to support higher pay, the employer can verify that salary history as they assess whether or not to bump up the candidate's compensation offer. And employers in Rhode Island will also now need to provide a wage range for a position upon request by a candidate or employee who is moving into a new position as part of the state's salary or wage transparency law. So again, in Rhode Island, you'll have to ban salary history inquiries, and you'll now have to include pay ranges with your salary postings. So speaking of wage transparency, here's a map that I put together for you. If you've attended my previous webinars, you know that I really like maps. I think they're a good visual way to depict what's going on. So the concept of salary transparency seems to be gathering traction. In this map that I've created, you can see all of the jurisdictions that require that you either post or provide a salary range for any open positions. So you can see it is gaining traction. So with that, what I thought I would do is outline some of the requirements behind wage transparency laws. And that's what you can see on this chart. I like charts just about as much as I like maps. So looking at the chart, it identifies the jurisdiction, the law's effective date, and when and how you need to be transparent regarding the salary or wages for a job, both for candidates and for existing employees. Most of these laws are already effective, so you should have processes in place to address them, but I want to cover them. I'm starting to see that there is an appetite for chasing down employers that aren't complying with these wage transparency laws. So it's really important that you be aware of them and that you put processes in place to comply if you are not already complying. So quickly running down the chart, in California, if a candidate asks you for the salary for a job, you have to provide that information after an interview. In Colorado, you need to include a salary range for all job postings. That's external postings for candidates, as well as internal postings for transfers or promotions. In Connecticut, you'll have to disclose the position's salary upon request or before a compensation offer to a candidate, and for existing employees upon that existing employee's request, or when hired, or when they change jobs. So again, when hired, you have to be transparent with new hires and transfers regarding where their salary lies within their range. And in Maryland, salary transparency is required for candidates upon request after they've applied. In Nevada, you'll need to disclose a position's salary after an interview for candidates and after an application or interview for a new position for existing employees. And you can see that I've included on this screen New York City in red text, as it is a jurisdiction with an upcoming effective date. That's May 14th, 2022. We'll talk a little bit more about New York City next. In Cincinnati and Toledo, Ohio, salary ranges are required upon request of the candidate after a conditional offer of employment has been extended. Rhode Island is another upcoming jurisdiction shown in red. We talked about it just a little a moment ago, but again, it requires wage transparency. And finally, in Washington, employers have to be transparent concerning wages upon the request of the candidate after a conditional offer has been extended, or upon request after an offer of a transfer or promotion has been made to an existing employee. So before we take a deeper dive into New York City's law, the practical takeaway is that it's important to conduct internal pay equity audits to assess the pay ranges within your organization for positions. And as you conduct those audits, to the extent that you have a sex-based pay discrepancy, you need to correct those discrepancies as you adjust your pay scales to comply with the applicable laws. And when you correct those pay scales, you can't just pay your high earners less. You need to bump up the pay of your lower range so that it is more equitable. And of course, it's important to ensure that you've established processes to communicate pay scales to your candidates as required by these wage transparency laws. So that is our overview of wage transparency. I do want to talk a little bit more about New York City's wage transparency law. The New York City Commission on Human Rights, they oversee all of the New York City anti-discrimination laws. They recently published guidance regarding the city's salary transparency law. Again, that is slated to take effect in May. So as drafted and passed, the law applies to companies who have at least one employee in the city and at least 4 employees in total. One substantive point that I want to raise is what's on your screen. The law applies to any positions that can or will be performed in whole or in part in New York City. That includes jobs worked remotely from an employee's home. So you can see how the concept of remote work plays into New York City's wage transparency law. Again, any positions that can or will be performed in whole or in part in New York City, including jobs worked remotely from an employee's law. It also applies to a wide range of workers, including traditional employees, independent contractors, interns, and temporary workers who work directly for a temp agency. Interestingly, the guidance also suggests that the salary transparency requirement only applies to jobs that are advertised. What's advertised? That's posted on the internet or internal job boards. So that's made available to the public. So that seems to suggest that if you don't publicize the job, then you don't have to disclose a salary range. Point being in all of this, the law as passed lacks clarity. So That's where some challenges come into place. On the screen, you can see a letter to the New York City Council that's drafted by the 5 borough chambers of commerce and the Partnership for New York City. That letter argues that corporate employers seeking to diversify their executive teams may offer higher compensation for candidates who are Black, Indigenous, or people of color, and that in the context of achieving diversity goals, the posted maximum for these positions may be significantly higher than the historical salary ranges, creating dissatisfaction in the workforce and demands to adjust existing pay scales that the employer may be unable to afford. The letter noted that workers of color are at a, quote, tremendous premium in a tight labor market. So this is a really interesting argument that's being made by the authors of this letter. It really is interesting that they're saying in order to attract diverse talent, they're going to have to pay this diverse talent more than their existing salary bands permit. And as a result, these wage transparency laws will cause a pay discrepancy to be known that causes an issue within the workforce. Really interesting argument. Further complicating matters is a new bill that's been introduced that would change and it would delay the city's transparency law. If the bill passes, the city's wage transparency law will not take effect until on May 15th, and instead the effective date will be November 1st. Most notably, the amendments to the law would not apply to remote positions. They wouldn't apply to to New York City-based companies hiring for a role at another location, and it would raise the minimum size of companies that must follow the law to 15 workers from 4. And that's a really interesting point because most, if not all, New York City anti-discrimination laws apply to New York City employers with at least 4 employees within their company. Moving it to 15 is a very, very big change by the city council. So as you can see, there's a lot in flux concerning New York City's wage transparency law. You can expect clarification later this month in advance of the May 15th effective date. But if you are a New York City employer, it may be worthwhile to get your ducks in a row and assess pay ranges and the processes necessary to communicate them, as you're going to likely have to do so no matter what in some way, shape, or form within the next several months. So let's take a quick sidebar and shift from salary history bands and wage transparency laws and talk about equal pay reporting laws. These equal pay reporting laws intend to provide for greater transparency concerning pay. If you are an employer in Illinois with more than 100 employees in the state, you're going to have to start reporting pay data on January 1st, 2023, next year. And you're going to have to obtain an equal pay registration certificate by the certification deadline set by the Illinois Department of Labor for each qualified employer. What's going to happen is the Illinois Department of Labor is going to, quote, collect contact information from qualified businesses, and it's going to assign each business a deadline by which it must apply for its certificate. So if you are a qualified employer in Illinois, be on the lookout for your notice from the Illinois Department of Labor and expect to comply with these equal pay reporting laws. And here is a map of pay equity laws that are on the horizon. These are laws that were introduced or had action in 2022 and are with legislatures that are still in session, whether that be regular session or special session. The states in blue are considering salary history bans. California and New York are considering wage transparency laws, similar to the existing laws of Colorado and New York City. So again, this would require that employers in California and New York post pay minimum and maximum salary bands. Mississippi is not considering a salary history ban, but is debating an equal pay law. It's actually been passed by the House and Senate and is on the governor's desk for signature. Interestingly, though, Mississippi's law is a little bit confusing as it relates to equal pay because the bill as passed by the Senate and House would permit a worker's salary history as being used to justify a pay discrepancy. So again, previous salary could be justified to pay a pay discrepancy. And the whole point of equal pay laws is to not look at previous salary. So the Mississippi bill doesn't do much to actually advance equal pay, but they are the last state in the nation to have not passed an equal pay law. Then there's Vermont and Virginia that are considering salary history bans and wage transparency laws. And Arizona is considering a bill that would include a salary history ban and an equal pay reporting law, much like the Illinois law that we just discussed. So stay tuned, and we're going to talk about what makes it across the finish line in our next quarterly webinar. We'll see what's changed on this map and what has actually become law. Let's move on to a quick discussion on privacy, technology, and employment issues that made waves in the first quarter. Here is a quick recap of privacy laws in the United States. Notable are the California Privacy Rights Act, which amends the existing CCPA, the Colorado Privacy Act, and the Virginia Consumer Data Protection Act. New to the list is Utah's Consumer Privacy Act, which was passed in this quarter. I'm going to provide an overview of Utah's law when we cover the next slide, but the important takeaways are that each of these laws basically require that individuals are notified concerning the collection, use, and retention of their data and given some control over their data. Now, here is the good news. Each law contains an exception for activities conducted in compliance with the FCRA, the Fair Credit Reporting Act. This is the law that regulates background checks at the federal level. So that means that background checks, which again are covered by the FCRA, are out of scope for each of these states' privacy laws. Now, your organization may collect, use, and retain other data outside of the scope of background checks that falls into the reach of these laws, so it's best to raise these issues with your legal counsel, and in particular, your compliance with the CCPA, Utah's upcoming law, Virginia's law, as well as Colorado's law. But let's talk a little bit more about the Utah Consumer Privacy Rights Act. So Utah's new law becomes effective on December 1st, 2023. So you have quite a bit of runway to comply. And just a few quick notes. Like Virginia and Colorado, Utah's law applies to information about consumers, not employee or business-to-business information. You can see the scope of applicability on the screen. There are rights to access and deletion and portability, but there is no right to correction, which exists in other state laws. Utah's law will require an agreement with entities that process information on the company's behalf. So look for data protection agreements to cover Utah's law. And unlike California, Virginia, and Colorado, Utah does not require companies to conduct and document data protection impact assessments. So it's lighter in that regard. There's no audit requirements on your part. The law also doesn't contemplate any cybersecurity audits or risks assessments. And again, background checks conducted in accordance with the Fair Credit Reporting Act or the FCRA are exempt from the scope of Utah's law. I think practically as it relates to you, though, for your non-background check related vendors, you should expect to start to see them engage in discussions with you regarding data protection agreements to the extent that they process your data. And here is an overview of the current state of tech and employment laws. Illinois has its Artificial Intelligence Video Interview Act, which requires that you provide notice and receive consent before conducting a video interview that includes artificial intelligence. Its Biometric Information Privacy Act also requires notice and consent before you collect any biometric information. So that would include fingerprints or face or voice scans. Similarly, Maryland requires notice and consent anytime facial recognition technology is used. So think about facial recognition technology and its impact on video interviews. And Baltimore outright bans the use of facial surveillance technology for anything other than access. So access is like access, for instance, to devices or buildings. So again, in Baltimore, video interviews that use facial surveillance technology are likely banned. And Baltimore actually imposes criminal penalties on individuals who wrongly use facial surveillance technology. So if you use any facial surveillance technology to do things like video interviews in Baltimore, be very, very wary. And new to our list is New York City's law, and we're going to cover that next. So here is New York City's new law that prohibits employers from using automated employment decision tools to screen candidates or employees unless a bias audit has been conducted prior to deploying the AI solution, the artificial intelligence solution. The definition of an automated employment decision tool, it's covered in the first bullet on your screen. Basically, it's any tool that supplements or replaces human decision-making that affects an individual's employment. The definition is relatively broad. So in practical terms, it could, in theory, include any statistical analysis that you've done to develop your adjudication policies. So to the extent that you've done some analysis to determine who or who does not make it across the finish line for your hiring policies, that could be statistical analysis that could be considered in scope for New York City's law. So that's just a little bit of food for thought as you understand how you might need to comply with this new law out of New York. You're going to have to undergo an annual bias audit conducted by an independent auditor and publish that information to your website. There's also a notice requirement. You have to provide notice 10 days prior to the use of an AI solution to your candidates. There's also a disclosure obligation placed on employers that's covered in the last bullet. So really big substantive changes that would occur to hiring if you use any statistical models in hiring, if you use any automated decision solutions, if you use any artificial intelligence solutions. The law goes into effect on January 1st, 2023. I'm really hopeful that the New York City Commission on Human Rights is going to provide some interpretive guidance prior to the law's effective date. As of now, I think that there is a lot up in the air with respect to compliance with the artificial intelligence and hiring law coming out of New York City. So here is a look of comprehensive privacy laws that are on the horizon. Again, when we're talking about laws that are on the horizon, these are bills that were introduced or had action in 2022, but have not been passed. Each of the states represented in blue on the screen are considering bills that are similar to the privacy laws passed in California, Colorado, Virginia, and now Utah. With state legislatures starting to wind down over the next few weeks, we may not see much more action in this space, but if anything passes, you're going to hear about it in our July webinar. Again, the good news, though, is that most, if not all of the laws that are currently being considered in state houses would exclude FCRA-related activities, so would exclude background checks from their scope, but they could include other employment-related data. And here are the biometric privacy laws that are on the horizon. Each of these states have modeled their bills generally after the Illinois Biometric Information Privacy Act, which means that if passed, the bills would require disclosure concerning the scope and purpose of collecting biometrics as well as an individual's consent. I'm going to quickly note that the Illinois Biometric Information Privacy Act has been a major source of class action litigation, because if you think about it, many employers collect biometrics in many ways. Some of you use them, for instance, as fingerprints for time cards or face scans for building access. If you're collecting any of these biometrics, they are then subject to the Illinois Biometric Privacy Act, and they would also be subject to any of the Biometric Information Privacy Acts passed in any of these states, which means that you would have to have a notice, disclosure, and consent process in place. If you don't, you wouldn't comply with the law, and you would be subject to either regulatory action or, in some cases, a private right of action, a lawsuit from individuals. So be really aware of how you use biometrics in your organization. To the extent that any of these jurisdictions pass biometric information privacy laws, they could really affect your organization, and you would need to be quick to comply with the laws of any of those states. So let's talk a little bit about California. At the end of March, California's Department of Fair Employment and Housing, the DFEH, discussed draft regulations concerning automated decision systems. What the DFEH is trying to do with its draft revisions is to update the regulations to address newer technologies like artificial intelligence or algorithms, which it refers to as, quote, automated decision systems, or ADSs. You can see some examples of ADSs on the screen. So the real impact of the draft regulations is that employers would be prohibited from using automated decision systems that screen out a protected class of candidates unless the use of automated decision systems are job-related and consistent with business necessity. So again, you couldn't use any automated decision system unless it is job-related and consistent with business necessity. there would be record-keeping requirements concerning the use of ADS and their impact on your workforce. So you'd have to conduct audits, and you would have to supply those audits likely to a regulator. So we're going to cover this in greater detail if the DFEH advances these draft revisions. Expect us to talk a little bit more about this in our July webinar. And with that, that wraps our privacy, tech, and employment discussion. So let's talk about cannabis reform. You'll hear me use the terms cannabis and marijuana interchangeably in this session. So again, cannabis and marijuana, they're the same thing. So please do not let that confuse you. I'm just doing it in order to offer some hope to those who believe that the term marijuana is a pejorative term, that it is rooted in discrimination stemming from activities that occurred in the 30s and 40s, and who are trying to move the to move basically the needle to using cannabis generally. But there are some people that feel that the term marijuana needs to be taken back and empowered. So we'll be using the terms cannabis and marijuana interchangeably today. So here is the medical cannabis map available at the resource library and in our cannabis ebook. Looking at your screen, you're going to see states in blue where accommodation is likely not required, states in aqua where anti-discrimination measures are in place and where accommodation is required, states in yellow where the regulation is silent, and states in light gray that haven't passed a medical cannabis law. And you can see that the maps have changed pretty significantly since our last webinar. Specifically, the number of states that require accommodation in aqua have exceeded the states that do not. We're going to cover those changes shortly. We're going to also cover Philadelphia's ban on pre-employment testing in a bit. But first, when I talk about cannabis accommodation, what I mean is that in certain states, you cannot discriminate against an individual just because they are a lawful cannabis user. Just because an individual uses marijuana lawfully does not mean that you can discriminate against that individual. And of course, the need to accommodate not only differs by state, but also by position. For example, there are typically, but not always, exceptions to accommodation for individuals in certain safety-sensitive or regulated positions. And here is our recreational map. As you can see on the screen, all states and cities in aqua, blue, or purple have legalized recreational cannabis, also known as adult use legalization. While locations in aqua have no impact on employers, those jurisdictions shown in blue or purple are different. Nevada, New Jersey, and Montana, which is new, shown in purple, allow for pre-employment testing for cannabis, but the statutes or the opinions that come out of these states say that an employer cannot impact employment due to a positive test for marijuana. And New York State has prohibited pre-employment testing for cannabis, much like Philadelphia. That bears repeating. Unless an exception applies, you cannot test for marijuana, you cannot test for cannabis for any candidate in the state of New York. Speaking of Philadelphia, let's quickly kick off our jurisdiction by jurisdiction review with a look at Philadelphia's ban on pre-employment testing for marijuana that came into effect at the start of the year. There are exceptions listed on the screen, which you can see. Basically, if you're required by federal or state law or regulation to exclude individuals who test positive for marijuana from hire, you can do so. But otherwise, you need to ban pre-employment testing in the city of brotherly love. And here we have Mississippi that legalized medical cannabis as of February 2nd of this year. Notably, there are very few protections in place for medical cannabis users, and employers do not need to reasonably accommodate the employment of a medical marijuana user. This means that employers can disqualify a candidate from hire or terminate an employee based on the results of a drug test that is positive for marijuana without considering impairment. Very few protections for marijuana users in Mississippi. A little different in Montana. Montana legalized medical cannabis back in 2004 and legalized recreational cannabis in 2021. A new bill in Montana, which became law on January 1st of 2022, amended the state's lawful off-duty conduct to include marijuana or cannabis as a lawful product. So what this means for employers is that you can't deny a candidate a job or discriminate against an employee because of their legal use of cannabis while off-duty and off-premises in non-working hours. So that is a dynamically progressive change of law in Montana. With that said, employers can take adverse action against an employee if an employee is impaired at work. And And here is another opportunity for you to test your knowledge. Same as last time, I'm going to give you a fact pattern and then ask you to decide the case. This is a case that comes to us from New Hampshire and focuses on medical marijuana accommodation. So here are our facts. The employee in the case, our plaintiff, suffers from PTSD. He is hired by the defendant, the defendant is an automotive dealer that sells wheelchair vans. The defendant has a policy that restricts drug use and requires drug testing. 2 months after the plaintiff is hired, he seeks treatment for his PTSD and is prescribed medical marijuana. The plaintiff then makes a written request to the defendant, his employer, asking for an exception to the drug test policy as a reasonable accommodation for his disability. In his request, the plaintiff makes it clear that he's not asking for permission to possess or to use marijuana at work. He just wants to be excluded from the defendant's drug testing policy. So what does the defendant do? The defendant denies the plaintiff's request and tells him that if he uses medical marijuana, he can't work for them. So the plaintiff notifies his employer that he's going to continue treating his PTSD with his medically prescribed marijuana, and as a result, the defendant terminates him. The plaintiff then sues the defendant for disability discrimination under New Hampshire law. So who wins our case? Did the employer discriminate against the plaintiff by not permitting his at-home use of medical marijuana? I'll give you a few seconds to get your decision in. Well, overwhelmingly, the respondents to the poll say that the employee wins the case. And you are 100% right. Verdict for the plaintiff. It's worth noting that initially the employer won the case. The original trial court found that while New Hampshire medical marijuana statute allowed medical marijuana, employers were not required to accommodate it since it was illegal under federal law. When the state's Supreme Court heard the case, they agreed with the lower court that New Hampshire's anti-discrimination statute clearly excluded the term disability, illegal drug use, and addiction. But the court said that illegal drug use or addiction was not the plaintiff's disability. His disability was PTSD, and as such, the plaintiff had a disqualifying disability under state law that could be treated by medical marijuana and for which the employer may need to reasonably accommodate. So this case tells us an important fact. Even if a state's medical marijuana statute does not expressly require an employer to consider reasonable accommodation of an individual's at-home medical marijuana use, you may want to consider that on a case-by-case basis, assessing the facts at hand. And here is a look at cannabis laws that are on the horizon. As you can see, we have only a handful of bills being considered across the US. Delaware and New Hampshire lawmakers are considering recreational measures. Voters in Maryland will get to decide whether to legalize recreational marijuana in the midterm election. South Carolina is considering a medical measure, and Louisiana is considering a bill that would prohibit employment discrimination of lawful users. So that is what's on the horizon. And again, we will cover anything that passes in our July webinar. So finally, COVID-19. Let's wind down with an extremely brief discussion of COVID-19's impact on employers. And I'm going to specifically focus on Form I-9 as I think that is what is most relevant at this point. We're going to start with updates from the Department of Homeland Security. If you'll remember, back in 2020, DHS, Department of Homeland Security, relaxed the I-9 process to allow for virtual inspection of employment authorization documents, or EADs, for fully remote workforces. Well, that virtual inspection process can continue through the end of this month, April 2022. But DHS's latest guidance extends this policy on a case-by-case basis, so it's no longer a blanket exception, and also it provides some clarity to us. As of April 1st, 2021, that's last year, the requirement that employers inspect employees' I-9 employment authorization documents in person applies only to those employees who physically report to work at a company location on any, quote, regular, consistent, or predictable basis. If an employee is hired after April 1st, 2021, and that employee works exclusively in a remote setting due to COVID-19 related precautions, they're temporarily exempt from the physical inspection requirements. But here is a very important reminder. any I-9s that you complete virtually have to be corrected within 3 business days of the DHS ending their virtual inspection process. Again, you have to correct those within 3 business days of DHS ending its virtual inspection process. And not to belabor the point, but if you have returned to in-person operations, then you need to physically inspect and correct any I-9s that were completed virtually. In the middle of the screen, you're going to see exactly what you need to do to correct the I-9. Once the documents have been physically inspected, you're going to note that the documents were, quote, physically examined with the date of inspection, and you're going to amend that on the Section 2 additional information field of Form I-9 or Section 3 as appropriate. Any audit of subsequent Form I-9s is going to use the in-person completed date as the starting point for these employees only. So practically speaking, if you're a HireRight client that uses our I-9 solution, you're going to use the corrections process to make these changes. Again, let us know if you need any more information about our I-9 solution when you complete today's survey or making those corrections. And again, I implore you to either start making corrections or form a plan to make corrections, as I have a strong suspicion that DHS may choose to withdraw the virtual inspection process in the very, very near future. I'd say that that is very likely on the horizon. And one more piece of practical guidance from Immigrations and Custom Enforcement, or ICE. ICE tells us that if you virtually inspected a worker's document and they're no longer with your company, they were either terminated or they left your company, you'll need to include a memo within the former worker's employee file that identifies the reasons that you were unable to physically inspect their employment authorization documents. So for example, if you were fully remote, you would need to include that as part of a memo. So this guidance suggests that you can't discredit I-9s of employees that have left your organization as not requiring additional attention once you return to in-person operations. While you don't need to correct their I-9s, you do need to memorialize the reason for your virtual inspection. So please, again, don't let this get ahead of you. Do it sooner than later. So here is a quick plug as you get in your questions for our Q&A discussion. We have several outlets of information for you to consume. So if something piqued your interest today, check out our resource library, our blog, or our Forbes articles to learn more. And you can even get a jumpstart and register for our next compliance webinar, which we're hosting in July. So I have time for just a question or two now, but if I don't get to your question today, we'll follow up with you after this webinar, and we intend to create a blog piece that will cover themes raised in today's webinar, at least themes raised by your questions in today's webinar. So let's get through a few questions. Let's see. So some questions about ban the box laws and their applicability to remote workers. How do we deal with remote workers as it relates to a ban the box law? Is it where they are living or where they will work? So the answer is it really depends on the specific law of that jurisdiction. A good rule of thumb, though, is to apply the more conservative or the more candidate-friendly law, I should say. So to the extent that a ban the box law is silent on its applicability, you may want to apply the place to which the individual is assigned to work. I think that is a good general rule of thumb for any laws, again, that are silent as you're dealing with remote workers. Questions about publishing pay ranges in job postings. Is this my definition of wage transparency or pay transparency? Again, it differs from a jurisdiction by jurisdiction basis, but there are some jurisdictions, Colorado and New York City's law, which was passed, that will require that you post the minimum and maximum salary within a pay within a job posting. For other jobs within the jurisdictions that we covered, you have to include it upon the request of a particular candidate. And in some cases, it also applies to employees that are transferring amongst internal positions. So again, you can read more about our pay equity resources using our pay equity white paper available within our resource library. Questions about the wage transparency laws as it applies to remote workers, specifically New York City's remote work and pay transparency law. If an employer is in Massachusetts, but they're employing people remotely in New York City, will the pay equity law apply? Again, New York City's law is currently in flux. As drafted, yes. Any employer, even any employee, even a remote worker, based on the law that has passed, which again is supposed to be effective in May, New York City's wage transparency law would apply. So you would have to be prepared to comply with that particular law. Again, you would need to include the minimum and maximum pay for positions within New York City, including remote positions, unless the bills are amended. And with that, we're really at the end of our time. So again, you can expect this webinar to be posted to the HireRight resource library shortly, and you're also going to receive an email with your SHRM and HRCI credit within a few days. As always, I'd like to thank you for your time today, and I implore you, again, take 60 seconds out of your day to complete our webinar survey. I take your feedback really seriously, so please let me know how I'm doing. It means a lot to me. And with that, we'll chat again in the summer where we're going to talk about what's made it across the finish line. So thanks again for spending a part of your day with me.